Encumbrances and effects on property ownership. An encumbrance is an imperfection or cloud on title. Think of the word cumbersome. That means burden. So an encumbrance is a burden on the title. An encumbrance is a charge, claim, or liability attached to real property. An encumbrance is a right or interest held by someone else other than the property owner. Encumbrances are clouds on title that may impair or lessen an owner's rights or property value. Liens and lien priority. A lien is a claim or interest in a property to secure payment of a debt. You throw money at it, the lien will go away. If the debt obligation is not paid, the lien holder may have the debt satisfied from proceeds of court proceedings or a forced sale of the property. A general lien affects all of the debtor's property, all of it, both personal and real. Here are some examples. A judgment lien, that's a general lien because the lien holder can force the sale of all of the debtor's property. An inheritance lien or estate tax lien, same thing. It is a general lien. An IRS lien is also a general lien because if you don't pay the IRS lien, the IRS can take, through court proceedings, all of the debtor's property. A specific lien attaches to a particular property or type of property, making the owner of the real estate responsible for payment. Some examples of specific liens are a mechanic's lien, where a mechanic does work to a specific house. Mortgage liens, because only a specific property is mortgaged. Real estate tax liens and special assessment liens. Condominium or townhome association liens. The creation of a lien may be voluntary, which is created by the action of the property owner. In other words, they signed a promissory note. That makes it voluntary. Some liens are created by statute. Those are statutory liens or involuntary liens. They are created without the express permission of the property owner, like property tax liens and mechanics liens. Created without the owner's permission, they are involuntary. The priority of a lien determines the order in which claims will be paid off or satisfied. Generally, liens first legally recorded are satisfied first. First in time, first in right. But real estate taxes and special assessments take priority over all other liens. So they will always be paid off first. Lien holders may establish a subordination agreement that changes the order of the priority of liens. Real estate tax liens include real estate taxes and special assessments. Real estate taxes are referred to as ad valorem. Ad valorem is Latin for at value or according to value. It is a tax that is according to the value of the property. Real estate tax liens are based on assessed value of the property. It is an involuntary statutory lien. Ad valorem taxes levied by government agencies such as school districts or water districts and municipalities such as states, counties, cities, towns, and villages. State laws may exempt some real estate from taxation, such as cities, governments, and religious and charitable organizations. Laws may also provide for exemptions from taxes or specific property owners or land uses. An easement is the right to use another owner's land for a particular purpose. Easements are not revocable once granted. An easement always transfers with the land at closing unless it's released by the holder of the easement. Easements must be in writing. Easements can apply to any part or portion of real property, including a right-of-way across the property or even the airspace above the property. And a pertinent easement always involves two separate properties. The parcel over which the easement runs is called the servient tenement. It serves the interest of the neighboring parcel. The neighboring parcel that benefits from the easement is called the dominant tenement. It dominates the interest of the servient parcel. And a pertinent easement runs with the land. It will transfer with the deed of either parcel, and it remains in effect until it is released. An easement in gross has only a servient tenement, like an easement held by a utility or a railroad's right-of-way. An easement by necessity is used to help a buyer purchasing a landlocked property. Easement by necessity goes with the word landlocked property. Think of landlocked property when you think of easement by necessity. An easement by necessity arises when an owner sells part of their land that has no access except over the seller's remaining land or over land owned by other people. An easement by necessity is only available to private owners. It is not available to governments, utility companies, cable companies, telephone or gas companies, or anyone else, only to private owners. An easement by prescription occurs when a party or parties uses another person's property continuously without the property owner's permission for a statutory period of time. State laws are required to create an easement by prescription. State laws define the time period required to create an easement by prescription. An easement involves two separate parties, one of whom is the owner of the land over which the easement runs. Easement must be in writing. Easements must be in writing. A party wall easement involves an exterior wall of a building that straddles the boundary line between two lots, or it could involve a commonly shared partition wall, like a fence or block wall between two connected properties. The most common ways easements are terminated one way easements are terminated is when the parcels merge. When the owner of one property becomes the owner of both parcels. Parcels merge. That will not terminate the easement until the owner records a release of easement in the property records. In other words, the easement remains in the public records even though the parcels merge. But merging the parcels will allow the owner or entitle the owner to a right to release the easement in the public record. When the easement is released, that's another way to terminate an easement. Or if the easement is abandoned, that's another way to terminate an easement. A license A license does not establish a legal interest in real property. It is permission to use someone else's property. A license is revocable permission granted by the owner or licensor to enter the owner's land for a specific purpose. An encroachment is unauthorized use of another owner's land. An encroachment occurs usually by accident, and it occurs when all or part of a structure illegally extends beyond the land of its owner or beyond the legal boundary lines. An encroachment is usually revealed by either a physical inspection of the property or a spot survey, or an ILC, which is an Improvement Location Certificate. An Improvement Location Certificate is a document that shows the location of all improvements on a property and shows whether they extend over the lot lines. Lis pendens is a recorded document that gives constructive notice of a pending lawsuit regarding title to a property. Other encumbrances of title include deed restrictions, which are privately created controls on land use. Deed restrictions are also known as restrictive covenants or CC&Rs. Deed restrictions are typically imposed by a developer to maintain subdivision standards. Deed restrictions may not violate fair housing laws or they will be invalidated. Deed restrictions are binding on all present and future owners. Homeowners Association regulations, privately created controls, another form of deed restrictions. When the communities managed by an association are restricted by policies and procedures dictated by the association, those are homeowners association restrictions. A developer transfers the right to enforce the CC&Rs once a certain percentage of the lots or units have been sold. Individual properties may be restricted to certain lot sizes, square footage, paint color schemes, and other factors affecting homes. In the case of deed restrictions, covenants, CC&Rs, regulations, and zoning, the most stringent or strictest requirement always applies, provided, of course, that the most stringent requirement is in compliance with the fair housing laws and so forth.